Good morning, folks, and welcome to the ResolveSH Matters platform. Today's session is called Understanding the Process, Federal Civil Litigation 101. I'm essentially inviting you to follow my lawsuit with me. Again, my name is Robert Velasco. Before I get started, a few folks have asked why the camera angle is from the side. It's because I'm reading a script, and I want to make sure that I'm not veering from the script. So anyway, for those who know me, you know I love teaching and sharing knowledge. I've been doing it for more than 30 years, often taking topics that many people believe are complicated or out of reach and breaking them down so they're easier to understand. Today we're going to do that with the federal civil litigation process. If you're one of my former students from yesterday or 30 years ago, welcome back. Dig in, baby. Today, I'm inviting you to do something that very few Americans have ever done. I'm inviting you to follow an actual federal civil lawsuit from the date it was filed until the day a jury reaches the verdict. This isn't a TV show. It's not a law school lecture. It's a real lawsuit. It's my lawsuit. It happens to take place in Missouri. One of the defendants is my former college roommate, David D.J. Johnson. Here's what I'd like to do. I'm going to pause this video. I want you to go back to the Facebook post associated with the video, and there I will provide for you step-by-step instructions on how to create an account in the federal PACER court system. Again, PACER stands for Public Access and Court Electronic Records. It's the federal system. And folks, these matters are a matter of public record. So I'm going to pause. In the instructions on the Facebook page, I'm going to give you the case number, which is, the case name is Velasco versus Boggs. Bennett Boggs is one of the defendants. He's the head of all of higher education and workforce development in Missouri. I'm going to give you the case number. And once you've created the account, come on back here. And essentially what I'm going to do in the instructions in the Facebook page is show you how to create the account and then take you to a place called the court docket, which is the official timeline of a lawsuit. Every time a party files a document or a judge issues an order, a new docket entry is added to the docket. Together, those entries tell the story. Once you've found the docket, come back and we'll finish watching the video, and I'll wait. All right, welcome back. Now let's walk through this lawsuit together and learn how the federal civil litigation process actually works. Every federal civil lawsuit begins the same way. A person or a business files a complaint with the court. That person or entity is called the plaintiff. Again, that's the person who filed the complaint. The plaintiff identifies the people or organizations they believe are legally responsible. They're on the other side of the aisle, if you will. Those individuals or organizations are called the defendants. In this case, I'm the plaintiff, and I've named 4 defendants: David D.J. Johnson, Julie Carter, Bennett Boggs, and Megan Lukey. Now, once the defendants get served the lawsuit, the defendants have an opportunity to respond. And sometimes they file an answer admitting or denying allegations. Other times they ask the judge to dismiss the lawsuit before the discovery even begins by filing what's called a motion to dismiss. Now, assuming that you're in the PACER system and you're looking at my particular case, take a look at docket entries number 13 and number 21. Those are the defendant's motions to dismiss in the case, even before they watch the 49-minute audio recording that I tell them that I have. Again, they're asking twice for the judge to dismiss the case before they've even watched or even requested the 49-minute recording or any of the evidence. They're just asking, please, judge, dismiss this case. Folks, this doesn't even make any sense. We're at what's called the pleading stage of the case, where someone pleads guilty or not guilty. Why are we asking the judge to dismiss the case at that point, that doesn't even make any sense to me. Now, again, assuming you're looking at the docket for my particular case, scroll down and look at docket entry 26. The judge has denied that motion. He didn't understand it either. Why are you asking that early? This is just when you file a complaint as the plaintiff, as long as you're presenting the case logically with enough meaningful input, the judge has to essentially accept that as being truthful until you get to the discovery phase where you start looking at evidence. They're asking the judge to dismiss it even before we got to the discovery phase. So the judge denied it. That doesn't mean that I won the lawsuit. It doesn't mean that they lost. It simply means that the case continues on to the next major phase, which I mentioned is called the discovery phase. And this is a simple step. It's a simple process step where both sides start to gather evidence. It's where documents are exchanged, witnesses are identified, depositions or interviews are scheduled, and each side begins learning what evidence the other side actually has. And a deposition is testimony taken under oath, or an interview of each defendant taken under oath before trial. Now, in that deposition, the witness promises to tell the truth, just as they would in the courtroom. That's important because knowingly making false statements under oath can have serious legal consequences, including potentially criminal liability for perjury. Now, here is where the Missouri case becomes particularly interesting. I'd like you to scroll down and look at docket entries 31 through 37. Take a look at the titles. Notice something. The focus of the State of Missouri Attorney General's office and the defendants shift. Instead of seeking discovery requests or seeing depositions or seeing motions for additional evidence, the State Attorney General's office and the defendants start filing motions that I believe are directly related to the ResolveSH Matters platform in my public videos. One filing, docket entry 31. They asked the court for permission. This is the State of Missouri Attorney General's office. Asked the court for permission to file a motion for sanctions under seal, like sealing an envelope. In my case, the state of Missouri asked the judge to punish me because they believe I broke one of the court's rules or orders. That's called a motion for sanction. Now, I'm not here to judge that. I'm just saying that the judge now has it in front of them to decide if what I did was right or wrong. I will tell you it's directly related to publishing ResolveSH videos. They think that is wrong. So they're asking the judge to seal it. Now, another docket entry, 33. Docket entry 33, the State of Missouri's Attorney General's office asked the court to allow those sanctions to be filed under seal. That means the state of Missouri is asking the judge's permission to file motions under seal. They want to keep that from being seen by the public. What are we doing? You don't want media attention. You don't want the public to see it. Folks, this is freedom of speech, all right? The docket and the complaints are a matter of public record. They want it to be done now under seal. Another docket entry, number 37, the State of Missouri Attorney General's office, again, the top attorney in the state of Missouri, is asking the court to stay the discovery. They're asking the judge to press the pause button while we figure out the sanctions and the seals. Could you pause things so that we can get you to decide on whether it should be sealed? Folks, think about that. Think about that for a moment. The parties have not even exchanged evidence yet. I just got what I requested as my initial round of discovery evidence. I haven't opened it yet. I think I got it, a day or two ago. But we haven't even exchanged evidence yet. No depositions or interviews have occurred, and yet significant attention is now being directed toward my public statements and the videos associated with my ResolveSH platform. The state of Missouri has already asked for 2 motions to dismiss. That's 2, asking the court to end the lawsuit now before we even go through discovery. They've asked for a motion for sanctions. Just hold everything, stop everything, and keep things under seal so it's out of public view. Folks, whether you agree with those requests or not, I'm not here to ask you to do that, and I haven't been from the start. They are now, the information and docket are now part of the official court record. That's why I wanted you to create a Pacer account, so you can read the docket for yourself. It's a matter of public record. Reach your own conclusions. The point of this video in Litigation 101, I don't want you to take my side. I'm simply using this as an opportunity to help you understand what you're seeing in the docket and help you understand the federal civil litigation process and why these filings become part of a procedural history in law. And I'm going to leave it at that for now. I hope you found this educational in nature. I hope this episode helps you understand how federal civil lawsuits work. Again, things in this whole process don't make sense to me. I'm a logical, chronological guy, and that's why I do well in litigation. But I wanted to share this with you. Thank you for joining me on the ResolveSH platform, Understanding the Process, the Federal Civil Litigation 101 piece of content. And remember, truth requires transparency and ownership.